The first thing on the agenda is roll call, so I will have all of the code compliance officers introduce themselves.
Mark Gibson, Code Compliance Supervisor.
Danny Ron, Code Compliance Manager.
Sam Schaller, Deputy Fire Marshal.
Ajoria Bailey, Fire Inspector.
Jessica Cotterman, Hearing Clerk.
Renee Kearney, Code Compliance Administrative Supervisor.
Todd Mead, Code Compliance Supervisor.
Thank you. Please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Next on the agenda is my statement about how the hearing is going to proceed this evening. I am going to read this so I don't forget anything. We are here tonight because the City of Deltona has contended that there are violations of the Deltona City Code that exist. Do I need to do anything with that? Okay. This is a public meeting, which means that no general public comment will be accepted, but each of the respondents and the code enforcement officers here tonight and any witnesses each of you call will be able to present evidence to me regarding each case and the violation of the Deltona City Code that is being alleged. I am an attorney and appointed by the City Commission to render decisions in these code enforcement cases to determine if a violation of the city code exists and what fine will be imposed, if any. If you are here for a Massey case, you might see that next to your case number on the agenda. That means that I will be determining solely whether you have come into compliance in a timely manner in accordance with the previous order the special magistrate issued in your case, and will not be reopening the case to determine whether or not a violation existed in the first place. Any decision I make this evening will be put into a written format in the form of an order. A copy of my written order will be provided to the city and then mailed to you as well. It is important to note that for any order I issue, you may appeal by filing a notice of appeal with the circuit court within 30 days of the execution of my order pursuant to Florida Statute Section 162.11. The procedure of the hearing today will be governed by Chapter 162 Florida Statutes. Formal rules of evidence shall not apply, but fundamental due process shall be observed and shall govern the proceedings. Hearsay is admissible, but only to support other competent and substantial evidence. If you are a respondent, you will be able to testify. Tell me what you think I need to know about your case, present evidence and witnesses. Your testimony will be under oath, so I will be swearing you in, and this hearing is being recorded. For each case, I will call the case number and the city will proceed first. The city has the burden of proving that the code violation exists. Then you will be allowed to respond. For each case, I intend to admit the case file and the PowerPoint presentation that will be shown this evening, and you should have received a copy of your case file when you came in this evening. If you did not, please let me know. However, I will admit the case file and PowerPoint unless a specific objection is received. I will take the cases generally in the order that you signed in, first come, first served. And I do have several cases that I need to announce that have been withdrawn or continued. So I have Fire 020-2025. There's no address for that one, but do you have an address for that one? Okay, 667 Deltona Boulevard. Fire 021-2025, 2160 Howland Boulevard, Suite 108. DEL 25-011, a Massey case, 1364 Rock Hill Street. DEL 25-024, 1264 Seagate Drive. DEL 25-056, 2811 Arendonda Drive. DEL 25-062, 2960 Norwick Street, DEL 25-064, 2558 Collingswood, and DEL 25-065, 3240 Elkham Boulevard. Those are with the withdrawn cases, so if you are here for any of those cases that I just mentioned, you do not need to stay. We will not be hearing your case this evening. In addition, we have one continued case, which is DEL 25-058, 1611 Giffen Avenue. So again, if you're here for that case, you do not need to stay. We will not be hearing that case this evening. I will go ahead and swear in everyone who intends to testify today as a group, which includes the code compliance officers. So if you intend to speak to me tonight, can you please stand if you're able and raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth? If so, please say I do. Thank you. All right. I have no ex parte communications to disclose, and we will go ahead and get started with the cases. All right, this is DEL 25-042 A and B, 1114 Cambridge Street.
Good evening, Special Magistrate. This is Gemma Torsivia, City Attorney, on behalf of the city.
Good evening.
Hello? Okay. Good evening, Your Honor.
Good evening.
My name is Josamar Jimenez, and I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL 25-042 A and B, the City of Deltona versus Fred Kelly II. The property address is 1114 Cambridge Street, Deltona, Florida 32725. The parcel ID number is 813-009-160-140. This property is being brought before the special magistrate for more than one violation. These violations are as follows. Violation A, this is a violation of the City of Deltona Ordinance Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make an application to the building official and obtain the required permit. The corrective action for said violation is you must either A, demolish the structure, in this case the retaining seawall, or B, obtain an updated boundary survey and riparian survey, as well as all other required documentation to attempt to permit the structure. Applications must be submitted to the City of Deltona. The structure must meet all requirements of city ordinance and be approved on final inspection. Violation B is a violation of the City of Deltona Ordinance Section 58-31, which states that the use of any city right-of-way, including appendages, and the use of any public lands under the authority of City Commission, except for their intended purpose, without prior written consent of the city shall be prohibited. Correction for said violation is you must either A, demolish the structure, in this case the retaining seawall, or B, obtain an updated boundary survey and riparian survey, as well as all other required documentation to attempt to permit the structure. Applications must be submitted to the City of Deltona. The structure must meet all requirements. if the city ordinance and be approved on final inspection. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to hearing. All the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. These cases originally started on May 24th, 2024, when a reporting party called Code Compliance, stating that there was a seawall in the lake being built at this location. I arrived at the location to investigate this report, where I noticed a pile of rocks next to the driveway, along with wooden boards and construction equipment, but I was unable to see the constructed wall since it was located at the rear of the property and the homeowner was not home. I left a courtesy notice along with my card for Mr. Kelly to reach back out to me. Upon further investigation, I reached out to the permitting department, and I did see a permit on file for the installation of 12 helical piers for foundation repair stabilization, which I was informed it was for the home itself, not for the seawall. On May 29th, 2024, I spoke with Mr. Kelly over the phone, and he came to City Hall that day to speak with permitting, where he was able to set up a scheduled meeting on July of 2024 with the building official, the Deputy Public Works Director, and the Code Compliance Manager at his property to view the structure. At this point, the owner was informed that engineer drawings will have to be made along with filing for a permit. Since the property involves a lake, the owner informed me that his land is being eroded into the lake and therefore is the reason why the wall was built. I also verified with the Planning and Zoning Department that in that area of the lake where the erosion wall was built, it is owned by the city. I informed Mr. Kelly that the property needs to be surveyed to confirm that if it is off his property, it needs to be removed at this time. The owner will then have the responsibility to remove the structure and restore the shoreline, or obtain an updated boundary survey and riparian survey, as well as all other required documentation to attempt to permit the structure. Mr. Kelly explained to me that he is not able to get engineer drawings due to the fact that he needs an updated survey, and the survey is not going to show that he owns that piece of property where the erosion wall was built. So no engineer drawings can be done. And he also informed me that it will cost him over $5,000, and he can't or shouldn't have to get a permit for something that's not on his property. He states that he needs the erosion wall to stop his land from being eroded into the lake. The lake is acting like a sump pump, and when the levels rise and fall, it is sucking the soil from beneath his home and property. The owner was informed by our Deputy Public Works Director during her visit to the property that measurements found the retaining wall is 50 feet plus outside the footprint of his property, which falls into the city's right-of-way. The retaining wall extends well past his property and does not provide or improve access to the body of water. And as far as we know, this homeowner did the construction as a DIY project with no engineered plans or updated surveys and did not obtain proper permitting for this construction. I informed the owner that had he pursued a permit with the city, there would have been nothing precluding him from constructing within his property boundary, but not on the city's right-of-way. In March of this year, 2025, I was able to have a meeting with my manager, supervisor, and public works director to consult with our city attorney about the correct ways to approach this case, and I then informed the property owner over the phone that we will be taking this case to special magistrate. A notice of violation was posted onto the property March 21st, 2025, and sent out certified mail, and then a notice of hearing, which I posted onto the property on June 6, 2025, and sent out certified mail. Mr. Kelly and I have been in communication, and he has tried to show me proof via emails that he has been trying to work with the engineers in getting the surveys and permits, but has not done so fully at this time. It has been about 13 months since this case originally opened in hopes that the resident would work with the city, and thus far we have been unable to obtain compliance. The city would like to request 60 days for the property to come into compliance or a fine of $25 per day per violation to be imposed until such a time that the property owner notifies the city of compliance.
Thank you. For the city attorney, did you want to add anything before I ask questions?
I do. Before I start, I just want to ask, the evidence that the code officer has entered, will the special magistrate accept it as entered, or should I go through and have it admitted individually?
Well, I usually in my ruling will say that I'm admitting the case file. Is that what you're asking me to do, just what's in the case file?
Yes.
Yeah, I will do that in my, when I make my ruling.
Okay. I just wanted to point out a few things, if I may. So there's just a couple things that we wanted to go over. The first one is on the issue of notice. As our code officer testified, proper notice was provided to Mr. Kelly. There is tracking information in the packet demonstrating that the mailed notice was delivered to Mr. Kelly's address and left with an individual there. We also have entered an affidavit of service in which our officer posted the notice of hearing on the front door of the property on June 6th, 2025 at approximately 12:04 p.m. And the notice of the hearing as it relates to this case was also sent via certified mail to the property owner. In addition, the notice of hearing and notice of code violation were posted at City Hall in the normal standard place that notices are posted at least 10 days prior to today's hearing. So on the issue of notice, the city has fully complied. I also want to just take a little bit of a step back here and talk through this case because our officer has done an excellent job. This case has been pending for 13 months, and candidly, this property owner has had more than enough time to come into compliance. And I think part of the challenge here is that maybe they don't understand what the issue is, although they do have an attorney. So I would hope that their attorney has told them. I will tell you that before this hearing, I emailed their attorney and called him in an attempt to try to get on the same page before the hearing, but unfortunately, he did not return my call, although he did email me. I will tell you that the wall was constructed without permission up by the city in the lake. The lake is owned by the city. And as I'm sure you know, Special Magistrate, any work that's constructed in the lake that occurs on city property not only is subject to the city, but it's subject to the related environmental authorities, which in this case would be St. John's Water Management District. They were not involved in the construction of this wall. And the city engineer, David Hamstra, had communications with Ms. Wallace, our assistant deputy public works director, just to let her know that there are impacts to building things in a lake, which is why when you go to build something in a lake, you have to have engineering. And that was not in place for this wall. There also would need to be written reporting to ensure that all of the work that is completed is in accordance with both city, county, and state regulations. Not only did this homeowner just frankly willy-nilly throw a wall up on property that wasn't his own, he has since tried to take a number of actions, but none of those actions are anywhere close to the law. So he has attempted to ask for a variance, has said that this isn't an easement and he wants to construct it on an easement. You cannot request a variance for property you do not own. That is not permitted in our city code. So that's not a choice. You cannot build on an easement that is not your own. And particularly if we did have an easement, he would need our permission. The city has informed this gentleman on more than one occasion via staff and the city attorney that the city does not permit people to build on city property. They have also informed him that he is welcome to come to a city commission meeting and ask for permission He has not done that. Not only has he not done that, but we would certainly not recommend that he be allowed to build a wall in a lake with no engineering, no approval from the city, no approval from St. John's Water Management District, and effectively take the position that because his property is sliding in the lake, which again, he did have permission to build on his property and install these, I believe, 12, I'm not quite sure what they're called, effectively pilings on his property, and he elected to do this instead. I mean, this case is, I mean, candidly, I think the code officer was very nice by requesting an imposition of a fine of $25 a day, but he's had 13 months to comply. He's been told he needs to remove the seawall. He has not removed the seawall. He has not submitted engineering to move it onto his property. And candidly, the expenses that the city has incurred with respect to engineering, legal, are mounting. And so I would strongly urge you to consider a more serious approach. Certainly, we would be happy to give him time to remove the wall. But this sort of fanciful idea that you can get a variance on property that's not your own or build on an easement that you don't own, even with permission, is out of order. There's also a little, I mean, and Mr. Huggins, I'm certainly you're able to speak when it's your opportunity, but you sent me a survey earlier today that was dated 6/15/15, and thank you so much. And I think you might have sent that to me in error because the survey that you had provided to the Planning and Zoning Department, I guess when you requested a variance, was updated in 9/18/2019 and 4/22/2025. And I'm happy to send this in if they don't have this admitted. But not only does that survey show that the seawall, it does show the seawall, that it's well outside his property line. It also shows a shed that was built outside his property line. So I'm sure that that was an inadvertent error, but this is not the conduct that we would expect from a homeowner, and certainly not the conduct we would expect when they've had this much time to come into compliance. With that, I'm happy to, obviously, the staff and I are happy to answer any questions you might have.
All right. I do have a question. So is there anything in the packet that actually is evidence that the city owns this property, where the seawall is located? Because I'm not seeing it. And I, can't rely on hearsay testimony only regarding that issue.
I do not believe it is in the package, although give me one moment. I'll let staff answer.
Your Honor, I have a map here, the plat,
Okay.
and
But then that's not in my code enforcement file, correct? I'm not seeing
no,
that.
ma'am. I've made copies in case you wanted to see them.
Okay. I would like to see it.
Okay.
Yeah. Yes. We'll make sure you get a copy.
That's too different.
Okay. And so tell me, where am I looking on this plat? What lot is owned by this gentleman? Okay, I'll give you a moment. I'll give you time to speak in just a moment, but let me ask my questions.
Staff, are you able to walk her through this?
Me,
Can you state your name for the record?
my name is Chad Tate. I'm the building official.
Okay, thank you.
Okay. If you look at where Lake Shelby is,
Yes,
lot 14,
okay,
that's where the gentleman's property is.
okay. And where on this plat does it tell me that the lake is owned by the city?
I have no idea.
So, Your Honor, if I may share my screen, I have on the property appraiser's website, and I'm happy to download this and send this to you, but I do have the property appraiser's site, which shows the subject parcel and then the lake, which is owned by the city. Would that be permissible?
Well, you can show me, but I'm not, I mean, I don't know that the property appraiser is necessarily definitive evidence that the city owns the property.
Okay, I hear you. So this is the subject parcel, 1114 Cambridge Street, that we're here on today. Can you see this on your screen?
I cannot see that. I mean, it's very difficult for me to see the screen over there to begin with, so I don't see. Okay,
Okay,
thank you.
but you can see a visual? But can you see my screen, I guess is a better question.
Yes, I can see it now.
Okay, so this little parcel is the subject parcel, 1114 Cambridge. And again, while I'm doing this, staff, if somebody wants to go and print this out, you could print 3 copies, one for the property owner and one for the special magistrate. That'd be great. This is 1114 Cambridge Street. So this is the subject property. This is the property that we're here on today. This is the lake. It's called Shelby Lake. And this lake is a parcel that is owned by the city of Deltona, which is 2345 Providence Boulevard. I'm happy to do this more info so we can get more info. So this more info takes us to this page. Can you see this, Your Honor?
I'm sorry, go ahead.
Can you see this map on the property appraiser's site?
The aerial?
The aerial, yes,
Yeah.
with a little green pin in the middle.
Yeah.
So this is Shelby Lake. So what I did is I clicked on the map to more info and it took me here. So as you can see, sorry, keep zooming in. The owner is the city of Deltona. And again, staff is, I believe, going to print a copy of this for you and Mr. Kelly and his counsel so that they can see it as well. Although candidly, I don't think there is a dispute that this lake is owned by the city. But certainly we have competent and substantial evidence that it is owned by the city. And, but again, I do not think that's a fact that's in dispute.
Okay. I guess, looking at can you go back to, I think one of the screenshots that you had was of the boundary line of the owner of lot 14. Can you go back to that? Because it looked, so my question is, it looked like there was quite a bit of property that was between the water body lake and the boundary.
You talking about my
Yeah,
PowerPoint?
the PowerPoint.
Okay, yes, ma'am. The PowerPoint?
You're talking about this.
My PowerPoint.
Yes, the code enforcement, yes, there you go. So you have the boundary line and quite a bit of property, kind of land, I guess, in between the water mark of the lake and, okay. That's just
Yes.
not really shown on the plat.
I have the survey that the applicant submitted to planning and zoning. I don't know if they're going to present it, but I do have it here and we can print it and share copies as well, although it is their
Okay.
record. I'm going to pull that up. Your Honor, can you see that? It's a survey, a boundary survey.
Yeah, yes. I mean, I can see that it's there. I cannot read it.
Okay. Yeah, no, that's okay. So I'm just going to zoom in so you can see what this says. So this is a boundary survey certified to Mr. Fred A. Kelly II. And it has the property address over here, 1114 Cambridge Street. And then I'm going to scroll down to the bottom. Now, this shows that it was originally taken on 6/15/2015. I just want to make sure you can see that. That's at the very bottom. the original survey date, and then it was updated twice. So as you can see in this red over here, it was updated 9/18/2019 and 4/22/2025. So this survey, and again, staff, it'd be great if you guys could print this and give copies to the respective parties. This is provided by Mr. Kelly through, I believe, council to the city's planning and zoning department, this survey. This shows the property. This shows the property line. It shows the approximate flood zone line, the ordinary high water line, and then the edge of the water. It also shows the seawall, which is obviously well outside of his property.
But
So
does-
this,
Go ahead. Does it,
I'm
but does
sorry.
it identify that it's the city that owns that property on the survey?
it does not, although
Okay.
it does identify that it is not owned by, that it is not part of this property.
Yes.
So it does not say owned by the city,
Right.
but it does say this is your property line, and obviously what's been built is well outside of the property line. And we can get you hard copies of this.
I mean, I will say, I'm reading the plat. I think it raises questions. It says, "The lake as shown on the attached plat is hereby dedicated to the joint use of the owners, abutting said lake, and said owners shall have the right to full access, use, and enjoyment of said lake for swimming, fishing, boating, and other lawful uses. Also, the waters of said lake are hereby dedicated to the governing municipal authority for the purpose of permitting unlimited activity in the installation and maintenance required in the drainage of the land covered by this plat." So,
No one is disputing that Mr. Kelly has access to fish or boat. That's not the issue here. But he does not have access to construct. Again, you cannot construct in a body of water without permission, not only from the city, but from St. John's Water Management District. I mean, we all know that Volusia County has a flooding problem, and Deltona in particular. You can't just be building permanent structures willy-nilly with no engineering, with no approval by any government body in a lake. I mean, the plat certainly does not dedicate the ability to construct to the property owner. It dedicates it to the government. And the government did not build that seawall. And the government's position is that that seawall needs to be removed and that he's had more than enough time to do so.
all right, I'm going to go ahead and hear from the property owner at this time. Can you state your name and address for the record, please? Oh, yes, thank you. I think you, there we go.
Yes, Arthur Huggins on behalf of property owner at 1114 Cambridge Street. Your Honor, I'll just address this quickly here in regards to this plat. If you also read under that next paragraph that you pointed out, it also reserves the rear 10 feet wide and 6 feet wide at the size of each lot is reserved to the Macro Brothers, Inc. So I think that also calls into question ownership of the city. In regards to notice, Your Honor, the requirements of the Florida Statute 106.2.06 first requires a person who reports the violation to disclose who they are. I don't believe the city has met 162.06B. And as indicated by staff, this case has been remained pending for quite a long time, and it's not because of Mr. Kelly. It's actually because the city could not figure out the legal position that they wanted to take in regards to the structure that was built. Florida law is clear, very clear, and I can provide you with 3 different cases that Mr. Kelly has littoral rights to build at his boundary. And Florida law states, and I'll reference you to BB Inlet Property LLC versus 920 North Stanley Partners, 293 Southern 3rd, 538. And it's clear that once the water recedes and there's a new boundary that is established, that becomes the property's owner's littoral rights. He can build whatever he wants to build there. He can build a dock. He can build a seawall if he chooses to do so. And I'll provide you with those 3 cases for reference. The main case
Have you shared these cases with the city attorney?
I have not, but I can give him a copy if he needs a copy.
Okay.
But no, I have not shared these with the city attorney. I had one brief conversation with him last week, in which, you know, we pretty much didn't get anywhere there. The city has already decided that they're not going to let Mr. Kelly even attempt to make a permit, and that's another issue with the notice. And the notice it's giving him options to come into compliance. However, the city has applied a prior restraint to him coming into compliance. Why? They won't allow him to apply for a variance. They won't allow him to apply for a permit. He hasn't even been able to put an application in and be denied. He's been denied from applying. That's a prior restraint on Mr. Kelly's rights. Not only that, again, 162.06 is clear on what's required to even establish a violation, and that is disclosing who made the initial complaint. I don't see that in the packet at all.
Are you referring to the prohibition on anonymous complaints?
Yes, Judge.
Well, did you make a records request for the complaint that started the case?
No, I made a record request for it, but there's none in the file. It's been provided to me.
Well, they're not required to provide it to you unless you are asking for it. I mean, can the city speak to how this case arose and whether or not it arose from an anonymous complaint or not?
She did actually testify that it arose from an anonymous complaint a little bit earlier. Maybe I misunderstood that.
I don't think she said that, but go ahead.
Yes, at the beginning of my speech, it was a complaint from a reporting party. So I guess someone saw it and saw that the Mr. Kelly was constructing the wall and decided to call Code Compliance Department and file a complaint. That information is on file, but again, that would be public records.
Mr. Kelly and his counsel never did a public records request for that information.
All right. Well,
That's inaccurate. That's inaccurate, Matt. Your
well,
Honor.
I'm not going to go back and forth, but I mean, the allegation is that it's arising from an anonymous complaint, which is prohibited by statute. So I do, need to have evidence of how the complaint arose. If you'd like to take a brief recess and come back, we can do that.
I mean, is it to disclose who made the complaint? Because that's in the public records. Like
Yes.
it's in the case. But
But it's not in my file, is it?
let me double check. That wouldn't be in the case detailed report, right? It would be in here?
Your Honor, is it okay if we do take how long of a recess would we be looking at?
Well, what I would propose is we could take maybe a 10-minute recess and come back. I could do another case or two in between.
Can I look at your iPad?
That sounds great.
I'm sorry?
That sounds great. We would appreciate that.
Your Honor, I can give that information to you in just a second.
Okay,
You
you don't, okay, if you can find the information quickly.
Judge, I can continue with my case law.
All right, go ahead.
In the Cardi v. Regions Bank Court of Appeal, 4th District, the court outlined the upland landowners' littoral rights and what they're inclined to be able to exercise. Says, based on Florida Supreme Court's early description of the nature of littoral rights, it is evident that littoral rights to accretion and reliction is distinct from rights to access, use, and view. The right to access and use and view are rights relating to present use of the foreshore and the water. That is not true for the right to accretion and reliction. Right to accretion and reliction is contingent upon future interest that only becomes possessory if and when the land is added to upland by accretion or reliction. And this is a case of accretion in which he's added to the soil of the land. It says accretions are additions of allusion to the waterfront land. Relictions are lands once covered by the water that becomes dry when the water recedes. In this case, the water receded and became dry behind his land. United States Supreme Court has noted in Florida at common law, the littoral owner automatically takes title to dry land added to his property by accretion. Any other rule would leave.
I'm going to interrupt you quickly. How do you know that this is dry land that has been accrued by accretion? What evidence do you have to show me that?
I have pictures of the land, Your Honor.
Okay.
And as
You're
well,
gonna print
as
that?
yes, as well as the survey.
Okay.
The survey clearly spells out where the water is currently at, which is at his seawall.
Okay. Can I also ask, but before you, and I just want to get my question out, even if I assume that there are literal rights here, my understanding of literal rights is that you would have the ability to build, let's say, a dock or a pier or another structure to actually reach the navigable area of the lake. You might have viewing rights, but I'm not aware that there are legal rights to build a seawall.
Yes, this case that I'm relying on it's actually it's alluvium that's separating the upland land, which is a structure. So it's not just, and that's why I read that first part to you about rights to access, use, and view. That's one right. But under littoral rights, he has more than just access, use, and view. He has a right to reliction and accretion, which is adding the soil to his land and making sure that the property is not subjected to erosion. This is the creation of the wall. So that's where, in regards to his littoral rights, he's entitled to do so. And that goes again to his constitutional rights as a landowner, as an upstream landowner to the lake.
But let me cut right to the chase here. How does that, even if that's all true, you're conceding, correct, that there was no building permit that was obtained to build this wall?
Yes, Judge. So as I stated earlier, they are in the violation to comply. They are saying attempt to get a permit. When he goes to attempt, which I have an email, and he's been there in person, when he's went to attempt to get a permit, he's been denied from applying because they're saying it's not on your property. So we won't even take an application from you. So that's an issue in regards to saying you can come into compliance by doing this, but we're not going to let you do it.
Well, one of the other options that is given is obviously to remove the structure.
Yes,
It was built with, I mean, I don't think it sounds like you're not disputing that it was built without a permit.
we're not disputing that it was built without a permit, but we are disputing that we are not being, he's not been given his due process to come into compliance. So in order to give a due process to come into compliance, he needs to have an application, and that application needs to be not denied, and they need to be able to reference why it's denied. I've asked for any ordinance or any permitted use that's on his land that he is actually in violation of, and they have not pointed to one. Only thing that they pointed to is a code in the building code that says you cannot put a structure up without a permit. Not only that, Your Honor, the other citation that they cite to, Chapter 58, it says on a public easement. This is not a public easement. So that violation is not even correct law as far as the ordinance goes. This is not a public easement.
It says, and the use of any public lands under the authority of the city commission, not just easements.
Right, but
So
there's no public land.
okay, so you're asserting that the property is not owned by the city, it's owned by your client.
I'm asserting that he has the new boundary. He has rights to that as far as littoral rights to build a structure on his boundary. Again, in regards to what the survey showed, his current survey that was required by the city, which he came into compliance with that, but they didn't again allow him to apply for the permit. But he did get the surveys as requested, and when he tried to submit those to the city, they wouldn't take them. So, according to the survey, it shows where the water is, and it shows where the seawall is, and that's at the boundary of his new property line, which is where the water has receded to.
Okay. What documents are you going to ask me to admit into the record? Because it sounds to me like you have surveys and other documents.
Yes, Judge. I have quite a few documents.
Okay.
One document that I have is going to show you the other properties that sit on the lake. And it's going to show you that those properties also have seawalls. And it's going to show that those seawalls are outside of what supposedly their land's boundaries. They showed you a wide view of the lake, and you'll see on that lake, if he goes back to it, you'll see on that lake there's other properties that have seawalls that are just like Mr. Kelly's, and they're outside of what the appraiser is reflecting to be outside of their property.
Okay.
And none of those owners have applied for a permit. None of those owners have been cited for a violation. In this case, it's only Mr. Kelly's property that's been cited.
How do you know that, sir?
We can look. We can show you the property.
a lake. Look on the other
Well, wait, pause. I'm not sure. Can you state your name? If you're going to speak, you have to state your name and address for the record.
Yes, good evening. My name is Mr. Liao. I'm a structural engineer, and I used to be the Deputy Director of Public Works here. So, and I know, and the reason that I'm saying that is that I tried to submit the permits for engineering, and they did not let me do it. And the other thing is that the product that is used there is approved by the state of Florida to be used in the state of Florida, and it was constructed properly. So I'm willing to certify that, and I'm not being given the opportunity to do that because the city says that it's on their property. And the other thing is, to remove it, you still need a permit. But there's 4 other seawalls on that lake. So the city's being arbitrary, they're being capricious, and it's wrong, unjust too.
Well, I mean, I don't know whether or not the city has any active code enforcement cases against the others. I guess I'm not really sure how that's totally relevant. But
Can I ask the city if they can provide that proof?
You may ask them.
Can the city please provide proof that the other walls were permitted, or have they received any code compliant notifications like I have?
I can tell you that we do have open cases on those properties across the lake.
Okay. Can I ask when that was done?
I cannot answer the question. That is dealt with a different officer. I apologize, Your Honor.
Can we ask the code officer, Chad, to testify? Because I spoke to him yesterday, and he said something contrary to what she's saying. And
You can't ask him to testify.
well, I understand that, but he represents the city, and he said he did not know if they had permits.
Ma'am, and this is just my understanding here, and I want to give you how this case came to.
Can you step closer to the microphone?
Sorry, yeah. I want to give you how this case came about, right? So this case came about was my house was sinking in after Hurricane Ian. We had a foundation company come out because there was foundation issues. The house was actually sinking on the backside. The foundation company came out, Alpha Foundations. We're going to submit into you their reports and their things, their permits. And they said that I needed a helical pillar and an erosion control wall. The salesman or the engineer or whatever he was that came into the house at that time told me, he said, you have the option to build it yourself, the erosion control wall, or we can build that, or we can have a contractor come out and build that. I said, fine, I will do that. It was under my assumption that that wall was underneath the original permit. Once they got their inspections done, everything was done there, the wall was still in the wall. The inspectors came out to do the helical pillars at that time, so they had access to it at that time as well. The city had access to it at that time as well when the helical pillars permit was filed. Then, and I don't have the time exactly, but it was when the first original code compliance was made against me. I stopped all construction. I spoke with Officer Jimenez about that. I said, okay, we won't do anything else. She asked me to go file a permit. I came down to file a permit at that time. When I came down to file a permit, they told me at that time that I needed to speak to zoning. Zoning told me I was unable to file a permit because it's on their land. At that time, this is how I got into contact with this engineer. He was standing next to me at that time, and he said, I can help you engineer the wall. I had let them know that I was attempting to engineer the wall. He did all the things. I got him all the things that were supposed to have happened for him to understand how I built the wall. We did that. We contacted the city. The city again said he asked for the city to permission to build on that easement if they are considering it their land, right? The city did not give me any responses to that. And then in October, I came to a city council meeting here. I spoke to Doc Daughtry. I spoke to the previous city attorney, and I spoke to two of the city commissioners that were at that meeting, okay? And the previous city attorney told me that I have littoral rights to that land. We're sitting right there. Doc Daughtry at that time said, hey, I need to take a little bit further look into this and understand what we have in all departments. I said, okay, absolutely. October went, November went, December went. Next thing you know, March is here. I haven't heard from anybody from the city in that time frame, in that lapse of time. And then I get another code violation and saying the same thing that the first code violation said. And I said, okay. So I contacted Officer Jimenez at that time and left a voicemail. I contacted her supervisor, left a voicemail. This is when I had 3 days prior to the April 1st deadline to become before the special magistrate. They got back to me on April 2nd and said, hey, we understand that you're trying to get the survey. I have emails to prove this as well, ma'am. You're going to have the survey. The surveyor said, I have about 2 weeks until I can get that survey to you because I'm busy right now. I said, absolutely. He said, they're asking for a riparian survey. The problem is that I can't give you a riparian survey because it's not a navigable waterway. He said, so I don't understand what the city is asking. Riparian means navigable waterway. He said, so what I will do is I'll give you a survey that states that where the current seawall is at, right? And I said, okay, absolutely. We'll go with that. He got that survey done on 4/25. I submitted it to the city. The city said, we're going in front of the special magistrate. That was the last time I came to see you. The city filed a continuance because they weren't prepared to present the case. And so here we are today, right? So for a year and a half, like their attorney has stated, that they've given me time, I've complied with every ask of the city the entire way. They asked me for an engineering plan. I get the engineering, but they can't engineer because we're waiting on the city. They asked me to permit. I can't permit. Matter of fact, yesterday, I came in to see if I could permit again. I was denied again yesterday the ability to permit again. Heather was the permitting officer's name. She sent me to zoning. I spoke to David Webster. David Webster had me email him the survey. Then I spoke to his supervisor, Jordan Smith, who both said you cannot even apply for the permit. So I've been denied the opportunity to even apply for the permit, for the city to even deny me.
Your Honor, if I may,
Yes.
Mr. Kelly does not have riparian rights.
Correct.
He just admitted that on the record.
He has littoral rights.
Look,
This is not a navigable waterway, ma'am. The littoral rights is what I have.
That's incorrect as well, because the analysis for that hinges upon whether the ordinary high water line is within his property line, and it is not. So you have the survey with you. I'm happy to share my screen again. But when we ask for a survey and you give us a survey that shows that the land is not yours, of course you cannot have a permit because your survey does not show that the land is yours. So I'm going to pull it up again and we can walk through this. So this is the survey that you all provided to us. And I believe there's a hard copy that you all have as well.
Yes.
Your property ends here. The ordinary high water line is this green line here. This is outside of your property line. That is why you do not have rights. That is why when this position you're taking, that as the water recedes, you get more land, that is not accurate because the ordinary high water line is not within your property. If this green line was here, your argument would make sense. But this green line is not in your property line, which is why you do not have those rights. And that property is not yours. So thank you for getting the survey, because I know you were attempting to keep this wall and not have to take it down. And we wanted to be helpful to you. However, when you give us a survey that shows that the land is not yours, of course we will not issue you a permit. That's like if you had given us a survey and you had tried to build a fence on your neighbor's property and you kept giving us a permit, but your survey showed your land ended here and the fence you were constructing was to the left, over here by this lot 15, block 329, right? No matter how many times you try to submit a permit to put a fence over here, your survey shows that it's not your land. You're never going to get a permit issued because you can't get a permit or a variance for property that is not yours. And your survey that you have presented shows that this property is not yours. And your argument does not, I don't want to say hold water, because I'm not trying to be flip about this, because the ordinary high water line is not within your property line, as evidenced by this survey.
Perfect. Can you please put back the thing that you submitted earlier with the entire lake with the property appraiser, please?
I'm sorry, what? I think we gave you a hard copy.
No. It's a shutter picture that you did. That can you expand that out, please, with all of the water, the boundary lines from the city, please, from the property appraiser?
The property appraiser does not show boundary lines. They show general marks.
Perfect.
Of
I need to see the
Those
whole
are
lake,
named
please,
property
sir.
lines.
The whole lake.
I'm not quite sure what you're asking for.
I'm
anything.
asking for you to show the whole lake where it shows Lake Shelby's boundary lines, please.
I don't have a map that shows that.
You just showed that 2 minutes ago, sir.
Your survey?
Yeah, with the green dot, the one from the appraiser site.
No, he showed it up here. He pulled it up here.
That's not a boundary. That's not a boundary map.
Well, that's what you relied on to say that it was a boundary line.
Ma'am, what I'm...
No,
ma'am,
that
what-
was a
ma'am,
no,
what
no,
I'm
no.
I'm not
That
gonna have-
demonstrated that it was owned by the city.
Ma'am, what I'm asking for is him to please just show us all the houses around the lake with the property boundary of the lake that he showed previously to this, not just my property.
You mean the property appraiser website?
Correct.
That does not show property boundaries. That shows ownership of properties.
Sir, I just want to see the thing that you submitted earlier with all of the properties on the lake. I may be using the wrong term. I'm not asking for the term. I'm just asking for the image that you showed earlier.
This image here
No.
that I have up?
No, the real satellite imagery of Lake Shelby, please.
Danny, let me ask, did you give this gentleman a paper copy?
It's not on a paper copy, sir. You brought it up in evidence on your screen, on your computer screen.
You're gonna have to give me a minute. You're talking about the plat that the code officer gave you?
No.
I'm not understanding what you're
You use
looking
the
for.
property appraiser site to make your argument that the city owns this lake.
It's a satellite photograph. You put a little green dot in the center.
Yes, the property appraiser website that you brought up.
Okay, so Danny, just so you know, I sent that to you so you can print it out and give it to everybody. I don't have that satellite image, but what I sent you to give to everybody is this, and I'm happy to put this up, but I don't actually think it's going to show anything that adds value, but happy to put this up, other than the fact that it's owned by the city. So this is,
The satellite imagery, please, sir.
Well, while we're waiting, you all did receive the plat and the survey, right?
I got this.
Correct?
Can I see
That's
these?
ours. We gave that to the city.
Okay, I'm just making sure that
Yeah.
you have the documents.
Your Honor, may I approach with these pictures?
It has them on there.
They'll get it from you if you want to.
Mr. Hill, you're welcome to admit evidence. I'm not quite sure what you want. This is what I sent in to Danny to print, to give to you and the special magistrate to evidence that it's owned by the city of Deltona, that the lake, Shelby Lake, that this parcel ID is owned by the city of Deltona. So I'm not quite sure what you're looking for. You're welcome to admit your own evidence. I'm not trying to stop you.
I did. Yes, sir.
But-
Thank you.
Do you want me to take this down?
Ma'am, in your hand, you have an image of multiple properties on the lake that show the property appraiser's thing where other properties have built outside of the said line onto city property.
I think we've already covered that.
Yes, yes. So my argument is that I have the littoral rights to the land. He's saying I don't have those littoral rights, but I have littoral rights to the land. Then that should give me the ability to apply and have the city give the denial and the reason for denial not coming before the special magistrate. It should have been handled where I could have applied, they could have denied the actual application and told me the reasons why. They chose not to. So here we are in front of the special magistrate to determine who owns the land now.
I'm going to explain this in a different way. If you came in with the survey that you submitted to planning and zoning, and you submitted a permit for a pool on your neighbor's property, we would not have processed that permit and denied it because you do not have the right to apply for that permit because you do not own your neighbor's property. And your survey reflects that you only own your property. So you cannot apply for a permit for property that you do not own. And your survey does not show that you own that property. It does the opposite. It shows that you do not own that property because the high water mark is not within your property line. So the analysis you're trying to make, and I understand what you're trying to make the argument, unfortunately, your survey does not support that argument because the high water line is not within your property.
So then
On the survey for the city attorney where it says is the in your view the boundary line of lot 14 where it says survey closure line and there's a dotted line that goes across?
Yes.
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 And then the ordinary high water line is outside of that property.
Yeah. Yes, Your Honor.
Your Honor, if I may give you the legal authority on that. It's going to be real simple for you to read it.
I mean, my only assumption that I have at this point is that I'm a disabled veteran. Everybody else on that lake is not. I do not pay any taxes, and I'm assuming that that's why the city is coming after me, because I do not pay any taxes. I'm a 100% disabled veteran, and I know those people that we're talking about, okay? Personally, I know that they did not permit the structures, and I know that they have not been asked by the city to date to have those structures removed like the city has asked me. So I'm just going to enter that in, and that's just speculation, but I'm going to tell you there's they are not veterans. There's no other veteran on that lake that's disabled. I would like to enter that in.
You can state that, but I am not taking that into consideration.
I understand.
That is speculation. So,
Magistrate, may I provide you with the legal authority?
yeah, you have these cases, though, available for the city attorney?
Yes, I can give it to him. I wish he was here in person, but I can give it to city staff.
I mean, you can give them to Danny, and Danny can scan them and send them to me, or he can give me the citations and I can pull them. It would have been nice to get these in advance, though. But we could take a 15-minute, and the special magistrate could, move on to other cases, and I can review. But
Yeah.
again, I
think
know
that
you
would
had a
be-
discussion.
I
Yeah.
think that would be good. I mean, I'm going to have to read them as well. And frankly, I think we've taken quite a lot of time with this case, and everyone else who's waiting here, I'm going to do those cases and we'll come back.
Your Honor, I'll be honest. We're happy to continue this to next month, as much as I don't want to do that. I want to give you an opportunity to read the authority that he's citing, and obviously I would like the opportunity as well.
Your Honor, I would not like to have that continuance based upon the fact that I told you last time that I actually work 2 weeks in Montana, 2 weeks here. When I have to request time off, that is a $15,000 a week problem for me, right? So I do not want to continue that. That is a very, very costly thing for me to have to do.
Well, the fact is, I mean, I have a lot of questions. I think, again, what I'm going to do is we're gonna just table this case until later in this evening for the moment, and we'll address the continuance request. But I think I'm going to hear the other cases for the people that are waiting here, and we will come back to this one. And I still have many questions. So I would like to, if you would like to pass up the authority and also get it to Mr. Ron so it can be given to the city attorney, that would be good. I'm not sure. I may continue this. I'm not sure at this point, but right now I want to hear the other cases for the people that are patiently waiting.
Sure. That's fine.
Thank you so much, Your Honor.
Sorry, guys. Thank you.
This is proof of what? Oh, okay. Okay. All right, we'll come back to that. Okay. All right, we're going to move on to another case. Which case is this? DEL 25-057, 570 East Normandy Boulevard.
That is me again, Your Honor.
Okay.
My name is Josamar Jimenez. I am employed by the City of Deltona as a code compliance officer. This will be case number DEL 25-057, the City of Deltona versus Carmen A. Hernandez. The property address is 570 East Normandy Boulevard, Deltona, Florida, 32738. The parcel ID number is 813-0013-70230. This is a violation of City of Deltona Ordinance Section 18-5, adopting the latest edition of the International Property Maintenance Code, Section 304.2, which states that all exterior surfaces, including but not limited to doors, door and window frames, cornices, porches, trim, balconies, decks, and fences, and shall be kept in sound working condition and maintained in good repair. Exterior wood surfaces other than decay-resistant wood shall be protected from the elements and decay by painting or other protective covering or treatment. The corrective action for said violation is to repair or replace the damaged exterior surface of the home. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All evidence in this case, including the photographs, have been marked as exhibits and submitted to Special Magistrate Clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. This case was opened on February 27th, 2025, when I initially noticed a blue tarp on the roof of the house at this property. As I got closer, I noticed also damage to the exterior walls of this property with broken wood and soffit around the front face porch area of the home. I spoke with the homeowner's son, Louis, who informed me that the damage to the house happened during 2024 hurricanes. A tree fell on the home and that FEMA is helping them fix the roof and exterior walls. He informed me that they have already received a check from FEMA, but it was not enough to fix the repairs of the roof and exterior walls completely, so they requested a requote from FEMA. I informed him of the tarp on the roof, and I was willing to give the 60 days for them to work with their insurance company and FEMA to get it resolved. I gave Louis my card along with a courtesy notice with the reinspection date, informing him to please keep in contact with me and let me know of any progress during the 60 days. I reinspected the property on May 1st, 2025, and found no change. The exterior walls were still damaged to the home, and I did not see any active permits applied for or on file for any future repairs, and I received no contact from the homeowner or homeowner's son from our last conversation in February. With no progress or change to the property, I proceeded to post a notice of violation. That same day, I received a not-so-friendly voicemail from the homeowner's son, Louis, sounding very upset, informing me that he received the notice of violation and is getting help from the city to get home repaired because they cannot get a loan and they have no money to fix the damage to the house. I spoke with our community and development department management team and asked if they have received anything as far as an application for help from this property. They went as far back as May of 2024 and saw no records of anyone reaching out to them. I gave them the property address along with homeowners' information so that they can reach out to see if this property qualifies for help. I then called Louis back with no response, left a voicemail, informing him that our community and development department will reach out to the homeowner. I received notice from the community development manager that same day, informing me that she was able to reach out to the homeowner's son, Louis, and his email to then send out the application process to them, giving the homeowner, his mother, until next week to follow up with them. The son can assist, but ultimately it is the owner's responsibility to reach out and contact the department. I gave 2 weeks to see if any progress has been made with the homeowner and the community and development department. On May 14th, 2025, I spoke with the specialist in that department who informed me that they sent out the application 2 weeks ago and the homeowner has not fully finished it. Therefore, they cannot proceed in helping them. The assessment form needed to be filled out after the application process, and owner has not completed or moved forward with any actions to proceed with them. I posted a notice of hearing June 6, 2025. I have not been able to speak with the homeowner during this entire case in progress. All communication thus far has been with the son, Louis. It has been approximately 4 months since this case initially started with no change or compliance from the property owner. The city would like to request 90 days for the property to come into compliance or a fine of $25 per day to be imposed until such time that the property owner has notified the city of compliance.
Thank you. You were discussing that, just want to make sure I got this right, that there was, what were they intending to apply for, the homeowner, that they did not?
Yes, Your Honor. So we have a program here with the city, the Community Development Department, and they help residents with any issues hurricane related to any damages like roof, exterior walls, etc. Because Louis, I spoke to him, he informed me that he was getting help from the city. I assumed it was for that department. I reached out to the director of that department and she informed me that they have not. So I then gave the information about the residents to the department and they reached out to Louis through email to send them an application. The application process, there's an assessment process and there's an application process. And then they also have to make sure that there's no property taxes owed on the property, etc. So there's a list of things that they have to make sure also no other code violations are allowed to be on the property. At that time, he had 2 other code violations on the property, so that was one of the reasons why, it kind of went that way. But the department sent out the email, and I do have a copy of the email here. It was sent out on May 29th. It was May 1st. That's when it was given to him. And then May 29th was when the department got back with me, letting me know that they spoke with Lewis and they advised them that they need to complete the application. The application process has several sections. It's 8 pages long. And unfortunately, B through I was never done. So when that happened, on June 6th, was when he received an email saying that the housing denied the application due to property taxes not being paid and overall application incompleteness. So they need proof that the property taxes were paid, and then they would be able to reapply within 30 days. Then I just received an email today at 9 a.m. from the department saying that they have proof that the property taxes of the amount of $781 were paid on the 23rd of June. So they no longer owe the property taxes. And then one of the associates that works in that department is working with the resident in order to get the application process finished. And that was today. So I have an email here from the department saying that Mr. Hernandez is complying with our request to complete the owner-occupied repair program documentation. He has overcome the first hurdle by paying all back property taxes. I opened his file so he can now upload the document necessary to complete the application. Per meeting on June 11th, we have given him a month to complete this documentation. Although we have not officially approved their request for assistance, we believe he is working towards getting all necessary documentation on time. We would like to give him 30 days as we promised him on June 11th to complete this. So with that, Your Honor, I was able to speak with that employee in that department, and he explained to me the process. And at that time, that's why I'm requesting the 90 days. That way, it gives them the 30-day buffer to get everything done, plus the 60 days to repair the roof or repair the exterior wall.
Okay. Is the program like a loan or a grant? What is it?
It's a grant
It's a grant.
for elderly people.
Okay. All right. Thank you. All right. Did you have anything else for me?
No, Your Honor.
Okay. Sir, can you state your name and address for the record?
Luis Hernandez and what?
Your name? Yes.
570 East D Boulevard.
Thank you. What would you like to tell me about the case?
Nothing. Just, we spoke today and we're in the process.
Okay.
I think the only thing I have, and I mean, this might be a stupid question, but my mom paid 30 years of mortgage. What does she actually own? Because everything is a problem, and I mean, I know you're doing your job. We finally, squashed the beef that I had with her. But it's like, the grass is is a little bit too long, or the easement, the right of way. It's like, what does she actually own? I mean, this is irrelevant right now, but I'm complying. I've been speaking to Mr. Gregory Jones.
Yes.
He's been very helpful. I've been in conversation with him for longer than this situation. That's why I said we were in the process of getting assistance from the city. So therefore, obviously, I guess it wasn't on paper, but I really don't have much else to say.
All right. And so you believe 90 days should be sufficient? I don't
know how long it takes to get the roof done, but
So I spoke with, yes, Your Honor, sorry, I spoke with my manager about the situation because, again, the process can be made, permits can be put in, as far as it actually being in compliance, like it actually being fully fixed.
Yeah.
We don't know that. That's sort of one of those things where we kind of have to figure that. I know hurricane season's here, and that was one of my biggest concern And I spoke to him today about that. You know, I would hate for us to go through this hurricane season again with, you know, the house in that type of condition, especially.
Well, at least the tree is not there anymore, so.
Yeah, and that's what happened.
That was the great part.
Yeah, and that's what happened. A tree fell, and it fell on the roof of the house. You know, hopefully nobody was hurt, but I mean, my major concern would be the health, safety, and welfare, of course, and that's why I gave the 90 days. Again, I'm open to giving it more time if needed, but I can't give you that answer as far as how long it would take.
All right. I think that it sounds to me like you are in the process of trying to work with the city to get it corrected. And I think I would suggest 120 days simply to give a little bit additional buffer, because even if he applies within the 30 days, then there's a processing of that.
Absolutely.
And then hiring who you need to hire. So I do want to try to give you time to do that without.
Yeah, 'cause my next door neighbor, my tree split in half, got her house. She has insurance, still not fixed. You know, so, you know, all of this stuff is in the air, but I will definitely try to get, you know, within the 30 days, all the information that's needed.
Okay. Well, I mean, so that's what I will do, but ultimately, it is your responsibility to fix the property to comply with the code, which means that, you know, the roof, and now, to be clear, it is the soft area.
I'm more,
correct?
yeah, so it's hard because as you can see in the photo, the roof looks to be intact. I don't really know 100% whether or not there's a leak or anything going on with the roof, but I specifically did the ordinance that includes the soffit and the trim, because that's what I can visually see that is damaged.
Yeah. So we're talking about that trim area and the soffits.
Yes, ma'am. The trim, the soffit, the fascia, and the eaves.
Okay. All right, I'm going to find respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on Thursday, October 23rd, 2025, which is 120 days from now. And in the event respondent does not comply by the state, a fine in the amount of $25 per day will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code compliance inspector to verify compliance with this order. So please make sure you stay in contact with her and let her know your progress so she can keep track of that. Thank you.
All right, thank you.
Thank you, Your Honor.
Is this where you arrested?
Okay. We're doing the other cases first. Is there anybody, are there other people here? All right, this is Fire 006, 2025, 2310 North Normandy Boulevard.
Thank you, Judge.
You're welcome, thank you. Wait, what page? 3.
Good evening, Your Honor.
Good evening.
For the record, my name is Samuel Schaller, employed by the City of Deltona as the Assistant Fire Marshal. Before I start to introduce this case, Your Honor, I'd have to apologize. There was an error that was made on the agenda for tonight. The violation description and the corrective action were, for lack of better words, they were flip-flopped from another case.
Okay.
So they do not reflect accurately on the agenda. However, the notices that were served, the notice of hearing and notice of violation for the initial case and the Massey case, they did have the correct violation and corrective action on them.
Okay, but this is a Massey case, correct? I see my previous order.
Yes, ma'am.
Okay. All right, go ahead.
All right, thank you. This case number Fire 006, 2025, the City of Deltona versus Normandy Holdings, LLC. The property address is 2310 North Normandy Boulevard, Deltona, Florida, 32725. Parcel ID is 81306 0000030. This is a Massey case. The statutory requirements for notification of this hearing have been met. The notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits, and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This was initially a case for a violation of City of Deltona Ordinance, Chapter 42, Article 4, Fire Codes, Chapter 42-186, which adopts the most recent edition of the Florida Fire Prevention Code as adopted by the State Fire Marshal, which contains the Florida-specific version of NFPA 1, Fire Code, Chapter 13.1.1, requiring that the authority having jurisdiction shall have the authority to require that construction documents for all fire protection systems be submitted for review and approval, and a permit issued prior to the installation, rehabilitation, and modification. Further, the authority having jurisdiction shall have the authority to require that full acceptance tests of the system be performed in the authority having jurisdiction's presence prior to final system certification. It was ruled on February 26, 2025 that the property owner was given 90 days to comply. Owner did not come into compliance within those 90 days, has been receiving a fine of $50 a day since May 28, 2025. As of today, the property has accrued a fine of $1,450 over 29 days. City is requesting that the fines continue at $50 per day until such property owner has notified the city of compliance and compliance is observed, or correction, is verified by a fire safety inspector.
All right, and so the violation was that they did not obtain a permit, correct, for the fire alarm cellular communicator?
A permit was issued back in, I believe, 2023 for the installation of the communicator. In April of 2023, Fire Inspector Lee Grosvenor conducted a site inspection in which she found additional work. The electrical feed run to the communicator was done without a permit.
Okay.
And that the communicator had issues with the cell service to report to the monitoring entity. Informed the contractor that a reinspection would be required, but that this would not be granted prior to an electrical permit being issued. The contractor came in on June 16th, 2025, so approximately 3 weeks after the date of compliance. And the contractor did request an extension for the permit. The reason they put was the work hasn't progressed enough to pass inspection. That was denied by Fire Inspector Lee Grosvenor because the electrical permit hadn't been obtained yet that we had been waiting for. And then, believe just recently an electrical permit was applied for. However, the contractor did not complete the permit application, nor are they a current registered contractor with Volusia County.
All right. So there were basically modifications that were made, and there was no permit submitted for that.
The permit was issued for the communicator,
Right.
but not for the electrical that was run to supply to the communicator.
Right.
So the communicator permit ultimately ended up expiring with no passing final inspection.
Okay. And that has not been resubmitted, the permit? Or it has been, but they have, I'm sorry, you said it has been, but they weren't even,
They weren't a current registered
right,
contractor
they
with
weren't a
Volusia County's contractor licensing board, and it was not a completed permit application that was submitted.
okay. Anything else, Mr. Schaller?
No,
Okay.
Your Honor, thank you.
Can you state your name and address for the record?
My name is Hector Lopez. I work with Dynafire. We're the contracted company.
Okay.
We did. The electrical contractor that was actually hired did submit it. Yesterday in the morning, we did receive the denied. He did receive the denied of the permit due to the paperwork that he still needed it to implement and send in. He did that yesterday in the evening. We have follow up everything. And as of 3 o'clock in the afternoon, the electrical permit, ELC 25-0049, it's been placed on review.
Okay.
So the city is reviewing it as we speak.
Okay,
Okay.
but it hasn't been issued at this point.
It's on the city's behalf.
Yeah,
We're waiting on them to give it
Sure.
to us. As soon as we do, we
Okay.
will proceed to ask for the extension of the fire and close out the permits as soon as possible.
okay. But nevertheless, that it hasn't been issued yet, and you said that it was submitted yesterday, correct? The date for compliance was May 27th.
Correct.
Okay. All right. Is there anything else you'd like to add? Okay. Okay. I'm going to find that respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case. And the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code compliance inspector. Respondent shall notify the code inspector to verify compliance. It sounds like you're well on your way to getting compliance. Unfortunately, it's beyond the time that was given, and that time was 90 days, I believe. So that's frankly quite a bit of time, longer than we usually give, or that I usually give. So I'm going to, that's my order. So please stay in contact and let him know when you receive the permit and come into compliance.
That wouldn't be a problem.
Thank you.
All right. Thank you.
Thank you.
Thank you, guys. Okay, let's go.
I don't think we have any more people over there.
Oh, there's not. Let me see. Is there anyone here for DEL 25-061, 2515 Howland Boulevard? No? Okay. So then I guess we'll come back to the other case, which is DEL 25-042, A and B, 1114 Cambridge Street. I had tabled this. I'm removing it from the table, and we're going to resume the hearing. Yes, we do need to get the city attorney back.
Yes, give me 1 second.
Okay. I guess, I have a couple of questions. I mean, one is, as a special magistrate, I am not sure how I have the authority to determine whose property this is. So that does concern me. That seems to be a civil matter that is unresolved, and I'm not sure how I am supposed to find violations without that issue resolved. I could, we could discuss the violation for failing to obtain a building permit, but the remedies or the things, to come into compliance, either by demolishing it or by obtaining the permit, as I understand it, they're not going to be able to do either of those things. So I'm really struggling with, A, my authority on this matter, and B, how I can find a violation if there is no possible way for them to come into compliance.
If I may, they can
Yes.
come into compliance by applying for a permit to demolish. You do not need to own property to demolish something you've built on city property.
Well, I think
So
the city
you
would
would
have
need a
to-
demolition
The
permit.
city would have to, if your contention is the city is the owner, I believe the city would at least have to grant authorization for them to apply for a demolition permit, correct?
They can. They've
And-
been
and
told they
you're-
can apply
you're-
for a
You're
demolition
saying the
permit.
city would. The city would grant
Yes, they have
authorization.
been told, yes, apparently yesterday, the planning and zoning director met with them and informed them that they could not get a permit to build something on land that was not theirs, but they could apply for a demolition permit. So they are welcome to apply for a demolition permit to come into compliance.
Okay.
The problem that I have with this is when I tear this wall down, we already have a foundation company stating that this is causing my damage to my home. So when I tear this wall down, if I apply for that, if I apply for that permit and I remove that wall, it is going to be damaging my home. So now that's going to lie onto the city for me to say, hey, look, I'm removing something that we know is damaging the house.
Well,
We didn't make you put that there. We told you don't put that there.
well,
Your Honor, he's able to build the wall, but it would have to be on his property line, like, you know, on the outside. The issue is that he built it in the lake. So if he put it the same wall, but put it on his property and get a permit for it, it shouldn't be a problem.
well, I mean, isn't the reason that it's in the lake to begin with is that at least the claim is that the lake is eroding his property.
We
So I
don't
don't
know
know
that
how
because he
that
did
would
not
help.
apply. He didn't get an engineer, and he didn't have an engineering permit, and he didn't go through St. John's Water Management. So
Yeah.
we have no idea. It
Your-
sounds
Your
like
Honor,
a salesman sold him this.
He is, Your Honor, he's conflating issues. St. John's has nothing to do with this lake. They have no authority over this lake, and he can't show any proof that they do. This is a closed off lake that's surrounded by homes. It's not. It's not a
I don't-
waterway.
I've spoke with the St.
Saint-
John's Water River District, ma'am. I've spoke with them on 2 separate occasions. St. John's Water River District forwarded me to the Florida Wildlife Commission to make sure that there was going to be no violations from there. They were supposed to get back in touch with me if there was going to be any issue with me building, not in the lake, because it's not in the lake. It's at the edge of the lake. And they said, at that time, they had said, well, there is no, oh, sorry, let me get closer to you so you can hear. I had spoke with the St. John's Water River District. They said that it's not in their jurisdiction because this is not a river, lake, or stream that touches the St. John's tributary of the St. John's River, okay? So they said they do not reside over this. Then they sent me over to the Florida Wildlife Commission, FWC. FWC had spoke with me. I spoke with them about 30 minutes on the phone, and they had said, hey, we will have our agent get in contact with you if they deem that what you have already proposed is going to be something that they need to investigate. They have not investigated to date. I've also contacted the EPA. The EPA has contacted me today and has said that they do not deem that there's anything on the water line that is that way as well. So I've contacted 3 different associations, and I've done everything the city's asked
Well,
to date.
I appreciate that, but that, again, I mean, it's really not relevant.
Sure.
At this point, the violation is for failure to obtain, or at least that has been alleged, is failure to obtain a building permit, which is a city permit. So I'm not here to try and determine whether or not a St. John's River Water Management permit or any other permit from a different state agency is required.
Sure.
All I'm trying to determine is whether or not there was a violation of failing to obtain a building permit.
And Judge, if I may, I want to make one other point. They opened up a new case. This is not even under the existing case. So they're not complying with the statute. There was an existing case that they never prosecuted. They closed that case and opened up a new case alleging the same violations.
And how is that a violation of the statute?
The statute requires, if you cannot, again, the first case was opened up based off of a complaint, a citizen complaint. The second case, there's no impetus to opening up the case other than the fact that the city determined that, hey, now we're going to prosecute him for this.
At that point, they were already aware through a complaint of what was going on.
But they failed to prosecute it. They closed the case. You cannot close a previous case and then open up a new case alleging the same violation.
I don't know why you wouldn't be able to do that.
Oh, well, I can provide you with, if we continue this case, I'll provide you with the law on that. The AG has been very clear on that.
Okay. I mean, I don't see why, I mean, I think that's done all the time, that you would close
For
the case.
repeat violations. This is not a repeat violation. This is a violation that they cited,
Yes.
failed to prosecute, closed it, created a new case, and cited the same violations again.
Again, I don't see what the legal problem with that is. If you've closed a case and you declined to prosecute it initially, but then determined later on that there was a case to be made, I don't know why they couldn't do that. But I'm not aware of any authority that would suggest you couldn't open a second case.
I'll provide you with that, Your Honor.
Your Honor, the initial case, I never closed that. The first case, that case has always been opened. I did open a second case for the second violation. There's 2 violations. So the initial case was for the no permit for the erosion wall. And then when we spoke with legal, we decided to go ahead and open another case for the right-of-way. So I don't know if that's what he's talking about, but that's what I did. I had never closed a case and reopened it. It's always been that. And I do have the, I don't know if I provided you the complainant information.
Yeah, I do have that.
So I'd like to give that to you guys. So that gives you the information of the original complainant, name, phone number, and address.
So it was, I assume that's maybe Shannon?
Yes, ma'am.
Warren
Yes, Your Honor.
as the complainant. So I think that resolves that issue. That demonstrates that it was not the case was not initiated based on an anonymous complaint. Okay.
Your Honor, if you would like it, you don't need to consider it if you've already, this is already common knowledge or provided by opposing counsel, but there is a case, Stop the Beach Renourishment versus Florida Department of Environmental Protection, in which it holds that the land that's waterward of the mean high water line remains in trust for the use and enjoyment of the people, and it remains owned by the property. So, by the government. And the littoral property rights that Mr. Kelly keeps referring to, again, do not apply because his property line does not encompass the high water line.
Judge, I've supplied you with case law that supports that he has littoral rights and what those littoral rights are.
Well, I think what I understood the discussion to be was that the lake has receded over time.
But that's not how accretion works. So the only way a property owner gets more land is when things are added to it. So the ocean is a better example. There are 2 types of beaches, right, on the ocean. Some beaches, the water pushes sand onto the land, and other beaches, the water erodes. When you have water that accretes and comes in from the water and adds sand or land, that does become part of the littoral property rights of the property owner, which would not apply here because his property is not within the high water line. But let's assume it was. This lake does not do that. He's testified a number of times that the lake is eroding and going back. It's not adding land. And when it erodes, you don't get the land when the lake water goes down. You only get land when it's added naturally through surf or a storm. But there has to be an addition of actual land, of material. The water line going down does not give you more land. That's not accretion. That's the opposite. And so, there's lots of cases on point. I obviously just cited one, and just so you know, the site for that is 560 U.S. So 130 from the Southern Circuit. And then there's another case, Florida's Beach Restoration
We're not talking about
case, which basically explains what I'm just saying to you. Save Our Beaches versus Florida Department of Environmental Protection. It's a case from the first DCA from 2006, which basically says that when land is added, yes, you can have littoral property rights. Again, that wouldn't apply here, but when just the water line goes down, you don't get land that way. That's not how littoral property rights work. It's contrary. But again, it's irrelevant because Mr. Kelly's property line does not encompass the high water line. So none of that analysis applies.
That's Florida Center right there.
Again, Judge, he's conflating what riparian rights are and littoral rights. Riparian rights are for beaches, navigable waters. This is not navigable waters. This is a lake. So we're on the littoral rights. He's citing
Littoral rights operate the same way. I mean, riparian rights.
I think the
riparian rights are the use to the water. Technically, a riparian is land with water frontage, specifically land abutting non-tidal or navigable river waters. Littoral refers to land abutting navigable ocean, sea, or lake waters. However, the terms riparian rights and littoral rights are used interchangeably. The littoral rights to access, use, view are easements under Florida common law. The rights are considered affirmative easements because they grant rights to enter, use the land in possession of another. Upland owners, such as Mr. Kelly, have common law littoral rights. The right to access the water, the right to reasonably use the water, the right to accretion and reliction, the right to the unobstructed view of the water. These rights are subject to regulation, are private property owners' rights that cannot be taken away without just compensation. Upland owners also have a qualified right with the consent of the state to erect wharves or piers or docks subject to lawful state regulations and dominant power of Congress. And that's
right here. That's
BB Inlet Property LLC.
But that doesn't respond to which I think makes sense, that accretion doesn't apply in this case because you're not adding property. There's not property being essentially, land being added here. You're saying that the water's receding.
Right, but again, so accretions are additions of alluvion to waterfront land.
That's sand. That's not water receding. That's when land is added, this lake does not add land.
Yes, it is.
But you know what? I don't want to interrupt, but Special Magistrate, you were right. This is about a permit and whether this was built in city right of way. If you want to reserve ruling on whether it was built in city right of way and city owned land, we're fine with that. But certainly it was built without a permit. I don't think anyone contests that.
Your Honor, can I just say here, I brought an expert witness here today to say how that land is being added to the lake. Can he speak for that as to how that is happening? Because if we're talking about accretion and how that's happening by a natural source, right, then that natural source, the rise and the fall of that lake, is a sump pump. It is pulling land from my land and adding it to the lake. That is a natural occurrence from hurricanes, from rain, and from everything else. So that is a natural occurrence as to how that land is being added. I am not coming in and adding land, nor is anybody on the city side coming in and adding land. It is an act of God that is adding that land.
All right. I guess, again, I am here to determine whether or not there's a violation of failure to obtain a building permit.
Your Honor, I've been trying to get a permit. That's the problem.
Yeah, understood.
So how can it be that there's a failure to get a permit when I've turned in the documents and they're rejected? They're not even looked at. They don't look at the engineering.
Your Honor, we're going to object to this witness. I mean, if they're going to try to bring in an expert, I mean, certainly we would need to see qualifications and I would want to cross-examine him. So if he's going to testify, I'm going to reserve the opportunity to cross.
Sir, you can look at human resources in the city because I used to work here. Okay, I'm a licensed engineer. Okay?
Well, okay. I don't see why we need to get into this issue because, again, it's not disputed that a building permit has not been obtained. Now, How you come into compliance and how much time you need in order to come into compliance is another question. And if there is dispute about, the city won't allow you to obtain a building permit because they're asserting that that is their property, that is not something that, as a special magistrate, I believe I have the authority to determine. I don't have the authority to determine whose land that is. But what I can do is provide time for you all to work that out, either through, your discussions and negotiations.
Your Honor,
or-
I have a question. Do you have the authority to ask them to?
I'm speaking.
I'm sorry, excuse me.
And I lost the train of thought that I was on.
About talking with the city and myself.
Yes, so there's time to determine, to negotiate that or discuss that, or to initiate, whatever civil proceedings you need to initiate to assert that you own that land and have the ability to obtain the permit. I think that is something that I can do in terms of giving a significant amount of time for you to resolve that. But again, I don't believe as a special magistrate, I am, able to, I don't have the authority to determine whose land it is. So, again, I don't think we need to get into, expert witnesses about accretion and how it's happening and things like that, because that's not within my authority to determine, again, whose land that is. I think that I think that is disputed at this point. So, with that said,
Judge, may I, before you make your ruling?
yes.
Are you able to define what compliance is and because again, the nature of the compliance that has been listed in the violation is to attempt to get a permit.
Yeah, I would clarify that. I think that so the compliance, I think that, again, there's two options for you. One is to obtain a demolition permit, which the city has stated they will allow and remove the structure, or for you to actually obtain a building permit and complete it. What's written here is that you would obtain a survey and attempt to permit the
Which he has
structure,
done.
but that's not really compliance. What compliance would be is actually obtaining the permit. So I would modify what the corrective action would be. It would be one of those two things. And again, I am happy to provide quite a bit of time for you all to, again, discuss the matter, try to resolve it, and if you can't resolve it, again, that's not in my purview to determine, whose land it is. So, I think what I'm inclined to do is find a violation of violation A, which is that there was no permit. However, give a significant period of time for compliance, which would be one of those two things, which would be either you demolish the structure or you actually obtain the permit. And, again, give you that time to work that out with the city. I am not going to find a violation B because I'm just going as, I don't believe that has been proved one way or another, whether this land is the city's or not. So I don't think that has been proved, and so I'm not going to find a violation of violation B. Is there anything either party would like to add before I make that formal ruling? I will give you one last opportunity.
Thank you so much, Your Honor. If he is going to demolish, we would be happy to give him, an extended period of time, 90 days, 120 days. If he intends to pursue another route, we would request that he be given a very short timeline in which to bring an action, because he has had over a year. He has not brought an action. So I would ask that, if he's going to bring an action, he's got 20 days. If not, we will give him 120 days to demo.
Judge, again, that's unreasonable. The first violation that they cited back in April gave him 15 days to correct. And now he's saying that he's been waiting the whole year. The city did not come down with a position until April. And there's plenty of evidence in the record that shows Officer Jimenez speaking with different building officials trying to get a resolution. And it wasn't until the Director of Public Works came and made a decision that he should be prosecuted for what's going on. So he has not had a chance to apply for a variance, which is Florida law. I've asked for the application. It has not been provided. In order for him to seek a judicial remedy, he has to go through the administrative process first, and that is being denied, which, again, he has not been allowed to apply. It's a prior restraint. So I'm asking for more time than just 20 days. That's unreasonable.
Well, what variance would you be seeking?
Well, if the city's position that they own the land, he's seeking a variance for permitted use to continue to leave his seawall where it is currently at.
He's not eligible for a variance because it's city land. I've stated this at the beginning of the hearing.
And I've asked you to provide an ordinance that states that.
He could have brought a quiet title action 13 months ago. He could have brought a quiet title action a week ago. There's nothing that there's no administrative requirement. No, you said he didn't exhaust administrative remedies, so he couldn't bring an action. He could have brought a quiet title action at any point.
Again, you just said that there's city ordinance that won't allow him to apply for a variance. Could you please provide that on the record?
No, I said that you can't apply for a variance for land you do not own.
Could you please provide an ordinance that you're referring to on the record?
You want me to tell you an ordinance that says you can't get a variance for land you don't own? I would say the implied value is you can only get a variance for property owners can get variances. You have to be an owner.
Well,
is it your, I hear you.
In terms of, this is only relevant to me in terms of how long I want to give you for compliance and
Judge.
efforts how long it might take you. I don't understand how a variance would help you in any of this situation. A variance is to allow for a use of property that's not permitted by code.
Correct.
But usually that's a zoning issue, and this is not a zoning issue.
Well, this is where they've been
simply
sending him to zoning and telling him he needs to speak with zoning the whole time.
Well, but okay. I don't see how that's going to help you. I think that the issue is if whose land this is I think up for debate. But ultimately, even if you assume that it's the city's, there is a process in the code right here for you to ask for the city commission to give consent for you to use that land. That's not a variance. That's asking the city commission for their consent to allow for it to remain. So,
Your Honor, if I may.
Yes.
The section of the code of ordinances that I believe you're looking for is section 110-113 variances. I'm not going to read the whole part, but the operative language is said variance application shall be heard only if it is presented by the person owning 51% or more of the specific area of land involved or upon an administrative application by the city commission. So it very clearly states that variance applications have to be presented by someone who owns 51% or more of the specific area of land involved.
Yes, but my other point is that I don't believe that a variance would be helpful in any case in this situation.
Agreed.
So
he was asking what says he can't get a variance, and I'm saying
the only
No, my question was a little bit different.
Okay.
I asked him to cite to me where he's stating that Mr. Kelly cannot build a seawall on the city's property.
I'm not sure why you need any citation for that if it's not on your property. But again, that's the question, right? Whose property this is. And I've said before, I am not here to make a ruling on whose property this is. So,
So with that is my question, ma'am, is that, you know, the city attorney stated that I haven't done anything for a year and a half. Oh, I'm sorry. The city attorney is making accusations that I haven't done anything for a year and a half to try to come into compliance with this. We can ask Officer Jimenez if I've been completely compliant with anything that she's asked for the last year and a half, and I would like to ask that on record. Have I been completely compliant with you on anything that you've asked for me to do for the city?
During our communications and everything, every time I've spoken to him, it's direction from directors. So it'd be, you know, building official, public works director, my manager. They would direct me as far as the information to give to him. And that's why the notice of violation was stated that way, because according to
I'm gonna object. I think he's attempting to cross-examine the code officer, and that's not proper.
why would that not be proper?
I'm not quite sure what he's trying to elicit.
Well, I mean, this is a quasi-judicial in nature hearing, and cross-examination is permitted. So I mean, if he wants to ask a question, I'll allow it. But I mean, I have a question, which is, when was the notice of violation for the building permit violation? When was that issued?
Let me go through my.
Your Honor, if I may, while she's looking, opposing counsel has continued to ask me where in the ordinance it says he can't do what he has done. If you would permit me, I can direct him to that.
Okay.
So if you look at section 58-31, it's use of cities right of way. It's in our code of ordinances. And A reads consent required. Pursuant to the police power of the city commission determines in the interest of health, safety, and welfare of its citizens that the use of any city right of way, including appendages, and the use of any public lands under the authority of the city commission, except for their intended purpose, without prior written consent of the city, shall be prohibited.
Yes, and that's what I just was explaining, that I mean, again, this is just relevant in terms of timing for compliance. I don't see that a variance is what really you're looking for. It sounds to me like again, this is just assuming that the land is owned by the city. You don't need a variance. You would need consent of the city commission under that section that the city attorney just read. So, but anyway, and that is not a lengthy process, right? I mean, that would be going to a city commission meeting and requesting it. But
If it was that simple, then why has not my communications with Emma Santiago, Doc Daughtry, and the previous commissioner and the mayor why has that not been spoken to me in those off-record conversations that's what I needed to do? And I know you can't answer that, ma'am.
Yeah,
but what I'm saying is I've had these conversations, I've had these deep conversations, and it seems like I'm just being led down a path that I can't either A, get it permitted, or B, it's just going to get demolished, right? From the city's standpoint. My argument is that I have the littoral rights. That's my argument, is I have littoral rights to do that. All the way up to build the structures on the wall per Florida statutes, right? Now I'm also going to ask at this point is, you're telling me like, hey, I'm going to give you time to file to make this in compliant. There's no way I can make this in compliant at that point, right? I can't file something where they're not going to allow me to file to come into compliance. So then the only thing that I'm being told by the city at this point is what, in my understanding is the only way that I can file anything is if it's to demolish the structure, which I am not going to file. I'll put that on record right now. I'm not going to file that because it is going to damage my home. So then that is going to make my house reputable worthless, which it almost might be worthless right now because a mortgage company will not issue a mortgage on that thing with the helical structures. So they're not. So my house is essentially worthless at this point, right? So in value purposes, because if I go to sell it, it won't be resold unless it's a cash buyer. So I have to save my home. How I'm going to save my home is to leave the wall in place. And if we have to let a higher court decide that, we'll let a higher court decide that.
Right. I think that's, and what not sure if you're understanding what I'm saying. When I say, if I find I'm going to find a violation of the violation A, which is the failure to obtain a building permit. And your options are to either demolish it or to obtain a permit. And if the city is not going to issue a permit and you assert that you own that property and have the right to apply for a permit, the ownership of the property is something that you would have to determine in a civil court, not here, in front of me.
Perfect.
All right?
Yep.
So I want to provide you with enough time to do that. So,
Can I ask my counsel how long that would take so I can ask for that?
well, I'm going to give you what I think is appropriate. Okay.
Judge, will you accept the evidence that we have so that
Yeah,
it's
so
record for
that,
appeal?
I do want to, thank you, because I do want to go over that, because I have a bunch of documents here for the record. Okay, so I don't need to admit, I have case law, I don't need to admit that as evidence, but that was turned in. We had I'm admitting the case file, and I'm admitting the PowerPoint presentation as evidence. In addition, I have, for the record, I have the Deltona Lakes Unit 9 plat, which is recorded in the Plat Book 25, page 178 and 179. And that was submitted by the city. I have a boundary survey of Lot 14, Block 329, Deltona Lakes, Unit 9, and this is dated June 15th, 2015. This was submitted by the city as well. I have a code case management sheet demonstrating the complainant that initiated this case, and that would be another exhibit submitted by the city. I have up here, and then I have aerial photographs. They're all dated February 15th. No, I'm sorry. 3 of them are dated February 15th, 2024. And then there's one, and these are all, okay, hold on. I apologize. Start over on that. I've got an aerial photograph of this property, 1114 Cambridge Street, dated 2/15/2024. I have one of 1929 South, is that Old Mill? Old Mill, dated February 15th, 2024. I have one of 1104 Cambridge Street, dated 2/15/2024, and I have 1919 South Old Mill, dated December 25th, 2024. And then I also have an aerial of the lake itself with the green dot in it, which is dated January 29th, 2021. Is there anything else that I'm missing? Those are the things that I have up here. I have not admitted anything else into evidence.
Your Honor, if I may, the green dot, that's the one from the property appraiser's website?
I believe so. This is the printout, and I believe, is this the one that the city printed out?
Yes, ma'am.
Based
It's
on the
from property
appraiser?
appraisers.
Yeah,
That's correct.
all right.
Danny, what about the one that says the owner, City of Deltona, that I emailed you, that I had pulled up? Did you give her that?
I do not have that.
I do have.
And
I do have that.
You have that? Okay.
I made copies if anybody sees it.
Thank you. Please give them a copy as well. Thank you so much, Mr. Ron.
All right, and then this is another printout from the property appraiser's website showing the same aerial, but it does have the property summary with the owner stated as City of Deltona. And that is another submission from the city. Now these 1, 2, 3, 4 aerial photographs of the property and the neighboring, that was from the respondent. That's all I have from you all in terms of documents.
The button.
We want to enter into evidence photos of the seawall. We want to enter into evidence the scope of work that was done. We want to enter into evidence the permit, the original permit that was approved. And we want to enter into evidence the engineering for the seawall.
What permit that was approved?
The original permit for the
helical structures.
The helical piers. That's
Okay.
That's on his property.
There's a pier?
No, from what I saw it's on the back end of his property. It's on the home.
Your Honor, if I may. It's a permit for helical piles so that the structure does not collapse.
I'm going to object. Again, if this gentleman's going to testify, I want to reserve cross.
That's fine.
How is that relevant
Well,
to, let me ask the attorney, how is that relevant?
Again, they're saying, because there's allegations here that my client is not attempting to come into compliance and that he has not applied for a permit. So this permit is proof that Mr. Kelly has been attempting to get the structure permitted and that he is attempting to come into compliance. So this is record on appeal that your magistrate has received evidence of Mr. Kelly's attempts to come into compliance.
But that's for a separate structure.
It's all related. That's the seawall and the structure that is permanent is all related to the erosion of his home.
We object to this evidence. This is irrelevant to this matter, which is whether he had a permit to build a wall in the lake that he's admitted to building. He's admitted to building it without a permit. We're not saying he never has applied for any permits ever. We're saying he has not applied or received a permit to build a seawall in the lake or at the boundary of the lake, however you want to classify it. This structure by his home is irrelevant.
Yeah, I think it's irrelevant too.
The reason why it's not irrelevant, again, he hired a private company to come out and assess the erosion on his property. They made a determination that he needed to have a structure at the back of his home and a structure at the start of where the water is in order to stop the erosion from occurring. Okay?
A permit doesn't tell me that, though. And the permit is limited to a different structure.
Your Honor, that's why I said we're submitting the scope of work as well as the permit so that there's an understanding of what Mr. Kelly contracted for in the beginning. He testified that when he applied for the permit, he was under the assumption that the seawall was included. Okay? The city has made allegations, multiple allegations, that Mr. Kelly hasn't done anything for a year to try to come into compliance.
All right. Mr. Ron, can you get the papers from?
Yeah, we are gonna object to this evidence. We are not saying no one ever said he didn't need to do something to improve his property. That's not what this is about. This is about whether he got a building permit, and he did not. So this is irrelevant if he has something that says he needs a seawall or he needs stabilization. That has no bearing on whether or not he got a permit to build the seawall.
What is this letter on the top? you're Mr. Kelly, correct? This letter is undated and unsigned. It says it's a request for clarification and equal enforcement of code compliance standards.
Correct, yes, ma'am. Yes, ma'am, that's the part of the conversation that we've been having here as well with the, I don't know, I think it's 1929 South Old Mill that has the exact same seawall that when you look on the property appraiser's site as well, that he's extended past that, past his supposedly boundary lines, if you're looking at it like the council has stated from the city. And so that's why I'm asking for that as well.
When did you submit this to?
I didn't, I'm seeing it so I can date it today and sign it today for you if I would.
Okay. This is not evidence, so I'm not going to admit it.
That's fine. I can withdraw that and that's fine. No worries.
Yeah, I'm not admitting that as evidence. All right, there's multiple photos of the seawall specifications.
Just, if I may, Your Honor, will you have a moment?
Can you have a moment?
I just want to ask if Mr. Kelly is making a code enforcement complaint against that address so that we can list him as the complainant?
No, I'm not. It's the duty of the city when Mr. Tate and your director of Public Works was in the back of my property to do the due diligence of the citizens to see that there was a violation that was there. I am not making a complaint on the record. I am not making a complaint against that address. But as a city official, when you stand in the back of an address and you see another code compliance issue, it's your civic duty to file that. So I am not doing that.
It is our position that you have just made that complaint on the record, but your objection to that is noted, but this is a recorded meeting.
Okay, I will admit these are photographs of the seawall and or retaining wall, and some specifications. I assume, City, you have no objection to that.
I have no objection to that.
So I'm admitting that.
The permit is in there, right?
That's 1, 2, 3, 4, 6. That's 10 pages, double-sided. I hope you're taking notes of this. All right, thank you. All right. There is a letter here, again, from Mr. Kelly. It's undated, it's unsigned. It says it's scope of work and construction description. I don't, this is not.
He'll object to that.
Yeah, this is not.
It's fine. We can withdraw it. It's fine.
Yeah, I'm not admitting that. I have the initial permit for the foundation work. It says it's
We'll
for
object to that as well.
installing 12 helical piers for foundation repair.
I mean, it is our position that not only is it not relevant, but this is not about whether he got a permit for that. This is about whether he got a permit for the seawall, which he's admitted he did not.
Yeah, I agree. I'm not admitting that.
Your Honor, again, it's relevant to the allegations that Mr. Kelly did not attempt to get a permit. It's wholly relevant to Mr. Kelly's attempt to permit the structure. He was under the assumption, again, that the seawall was a part of the original permit.
You know what? I'll admit it, but
Thank you, Judge.
I don't think that it demonstrates that. I think it demonstrates the opposite, because the description here is that the permit was for installing 12 helical piers for foundation repair.
Yes, Judge.
But I'll admit it.
Thank you.
I have a notice of commencement.
Is this for the foundation work?
It appears that way because the contractor is Alpha Foundation Specialists LLC. But, you know, this is just a recorded document, so I'll admit it. I mean, I could take judicial notice of a recorded document.
Thank you, Judge.
And then I have Alpha Foundation's groundwork.
Is this the company that did the work without the permit? Is that their admission?
This is,
There's no company that did a work without a permit. Just want that on record.
Well, they didn't have a permit and they did the work.
The wall was constructed by myself, not a company. Thank you.
this is, it,
I believe that's for the helical piers, Your Honor.
yeah, this is for the helical
There's a
piers.
drawing on the third page, report page 204.
Yes.
It's sort of circled in red. You can kind of see that's what they got the permit for. It's I believe it's
On the foundation.
It's on the,
building.
yes, ma'am. On the home.
Your Honor, if I may, Mr. Kelly just testified that he built the wall himself. I think I need to impeach him. Earlier in the hearing, he specifically testified that there was a salesman from a company who advised him he needed to put the helical spheres at the foundation and also build a seawall, and that company did both. So I guess he can have this
Your
opportunity
Honor, I'm
to
going
correct
to
the record.
object to that. That's a mischaracterization of the testimony.
Well, I mean, at this point, I don't think I think we all know that this was built without a permit. So I don't think we need to get into that discussion. All right, these are all stamped by the City of Deltona as being part of plan review and building services for the helical piers. I'll admit it was submitted to the City of Deltona. You know, this, again, is just for the helical piers. There's nothing here indicating any permit for the retaining wall or seawall.
Thank you, Judge.
So, I'll admit this, and that, I believe, is the last document. This is all from Alpha Foundations. So I will admit that. I'm sorry? You want to count the pages? All right. All right. I'm going to go ahead and make my ruling. I'm going to find, oh, hold on. I apologize, too many papers. How many? Oh, you're still looking. All right. So I'm going to find respondent in this case in violation of the city code as charged, and that, I'm sorry, let me revise that. I'm going to find respondent in this case in violation of the city code with respect to violation A, which is City of Deltona Ordinance, Section 105.1. And
Judge,
yes,
I'm sorry, that's not the ordinance, is it?
it is, what
The
is,
city, you're referring to the code.
yeah. It is Section 18-3, which adopts the latest edition of the Florida Building Code, Section 105.1.
Yes, Your Honor.
Yes,
All right.
Your Honor.
So I'm going to find the respondent in violation of the city code with respect to violation A as charged, and that respondent correct the violation before 4:00 p.m., and I'm going to give 6 months to come into compliance, which would be, I'm sorry? 34 pages, all right. I'm going to give a little bit longer because that falls on Christmas Day. So I'm going to do January, I'm going to do January 9th of 2026, which is slightly longer than 6 months. All right, in the event respondent does not comply by the state, a fine in the amount of, and I'm going to say it's, well, the city requested $25 per day, so that's what I'll do. And the amount of $25 per day will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code compliance inspector to verify compliance with this order. I'm going to specify in my order that your corrective action, as we already discussed, would be either to A, demolish the structure, or B, to actually obtain the building permit, not just to obtain surveys and attempt to obtain the permit. And I believe that this amount of time will give you the time necessary to either, as I said, discuss with the city of Deltona what your options are and resolve the dispute, hopefully, but if not, to take your dispute to the appropriate court to determine who owns the property and who has the ability to apply for the permit. All right? I'm going to find that I'm going to dismiss the violation B, which was section 58-31, because it is the city's burden to prove that there was use of public lands under the authority of the city commission without prior written consent. And I just don't believe that the city has carried the burden of proof there to demonstrate today that this is, the city's property. And again, I think that that really is outside of my realm to determine that question. So I'm going to dismiss that one. And that is my ruling. As I said before, I'm omitting the case file and the PowerPoint that was given today, as well as the exhibits that I previously listed. And I find that the notices were properly given here. Thank you. I think we've concluded that hearing.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
I can keep this.
Yeah. May I get the withdrawn evidence back, please? The letters, or no?
Yes.
Thank you.
Just keep in contact.
Yep. All right, thank you.
Can you take these to him? Okay. Do you need, sir, the case law that you provided? Okay. No, I'll keep it. We'll put it in the file, but as I said, I didn't admit it as evidence. All right. The next case is DEL 25-061, 2515 Howland Boulevard. Good evening.
Good evening, Your Honor. My name is Janice Palasic, and I am employed by the City of Deltona as a Code Compliance Officer. This will be case number DEL 25-061. The City of Deltona versus Rafael Sells, EST. The property address is 2515 Howland Boulevard. The parcel ID number is 811-500-000-100. This is a violation of City of Deltona Ordinance Section 18-5, adopting the latest edition of the International Property Maintenance Code, Section 302.7, which states all accessory structures, including detached garages, fences, and walls, shall be maintained structurally sound and in good repair. Corrective action for said violation is to repair or remove the structure. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted onto the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that they were taken. This case was opened on March 20th, 2025 for offense in disrepair. I noticed that there was a metal fence in disrepair along the front of this property. The property appeared to be vacant, and I was unable to access the main dwelling due to overgrowth at the driveway and the property being gated. I posted a notice of violation on a stake in front of the main gate leading into the property. Upon reinspection on June 6, 2025, the fence was still in disrepair. Still unable to access the main dwelling, I posted a notice of hearing on a post in front of the main gate leading into the property. I have not had any contact from the property owner. As of today, June 25th, 2025, the property is still in violation. The city would like to request 30 days for the property to come into compliance or a fine of $25 per day to be imposed until such a time that the property owner has notified the city of compliance.
Thank you. So you said this is a metal fence?
Yeah, it's a wrought iron fence.
Okay.
And it's all
And is it
rusty.
leaning? Is it falling? It's hard
leaning,
to see in the
it's-
pictures.
it's hard to, now there's a lot of overgrowth, but there's sections that are missing, there's pieces of metal that are exposed, sharp edges and stuff like that.
Okay. Thank you. I'm going to find respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on July 25th, 2025, which is 30 days. In the event respondent does not comply by the state, a fine in the amount of $25 per day will be imposed for each day the violation continues past the aforestated date. The respondent is further ordered to contact the code compliance inspector to verify compliance with this order. Thank you.
Thank you.
Oh, I'm sorry, and I'm admitting the case file and PowerPoint as exhibits, and I find the notices properly given in this case. Thank you.
Thank you.
The next case is DEL 25-063, 1713 Concert Drive.
Hi. My name is Janice Polasic, and I am employed by the City of Deltona as a code compliance officer. This will be case number DEL 25-063. The City of Deltona versus Hector Enrique and Naricera Jutaris Toro. The property address is 1713 Concert Road. The parcel ID number is 813-045-330-050. This is a violation of City of Deltona Ordinance Section 66-19-3, which states that boats, trailers, and recreational vehicles shall not be parked or stored either within a public right-of-way or within the portion of the lot lying across the full width of the lot between the front lot line and frontmost part of the principal structure. Corrective action for said violation is to park the boat on the side of the house behind the front face or in the rear yard, but not within the side street yard. Please move the vehicle to proper parking area or remove from the property. All vehicles must have a current tag and be operable, or they must be stored in an enclosed garage. Statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that they were taken. This case was opened on April 23rd, 2025 for a boat that was improperly parked on the side of the driveway with a tarp covering it. On April 26, 2025, after given time to see if the boat had just been used or was going to be used, I noticed that the boat was still improperly parked on the side of the driveway with the tarp covering it. I spoke to the male resident through the Ring video doorbell and explained to him the violation as well as the corrective action. I also left a courtesy door hanger with the violation and corrective action. On May 7, 2025, the boat was still improperly parked on the side of the driveway. I proceeded to post the notice of violation to the garage door. Upon reinspection of this property on June 7, 2025, I noted the boat was still improperly parked on the side of the driveway with the tarp covering it. I then posted a notice of hearing to the garage door. As of today, June 25, 2025, the property is still in violation. The city would like to request 7 days for the property to come into compliance or a fine of $100 per day to be imposed until such a time that the property owner has notified the city of compliance.
And so the compliance would be just moving it behind the front building line, correct?
Yes, Your Honor.
And what is the reasoning for $100 a day? That's pretty significant.
We do have a fee schedule that was set by the manager for different violations, and that's for all vehicles, we have a fine for $100 per day.
Okay. Well, I determine whether or not what the fine should be. And $100 a day seems pretty significant. So, okay. Is there anything else?
No, Your Honor.
All right. So, I'm going to find respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. I'm going to give additional time, primarily because I don't think we will get the order completed in 7 days.
Okay.
And, so I'm going to give some additional time, but not much. I'm going to give until... on the calendar. Forgive me. I'm going to give until July 11th, Friday, July 11th. So that would be, 4:00 p.m. on Friday, July 11th. In the event respondent does not comply by the state, I'm going to impose a fine in the amount of $50 per day. Which will be imposed for each day the violation continues past the aforestated date. The respondent is further ordered to contact the code compliance inspector to verify compliance with this order.
Thank you.
Thank you. All right, the next case is Fire 018-2025, 1200 Deltona Boulevard.
Good evening.
Good evening.
All right. For the record, my name is Jory Bailey. I am employed by the city of Deltona as a fire safety inspector. This will be case number fire-0018-2025. The city of Deltona versus Deltona Wellness LP. The property address is 1200 Deltona Boulevard, Suite 23 through 26. Deltona, Florida, 32725. Parcel ID is 813-0060000020. This is a violation of the City of Deltona Ordinance, Chapter 42, Article 4, Fire Codes, Chapter 42, 186, which adopts the most recent edition of the Florida Fire Prevention Code as adopted by the State Fire Marshal, which contains the Florida-specific version of NFPA 1, Fire Code Section 13.1.8, which states all fire protection systems and devices shall be maintained in a reliable operating condition and shall be replaced or repaired where defective or recalled. And Section 13.7.3.1.1.4 of NFPA 1, which states all apparatus requiring rewinding or resetting to maintain normal operation shall be restored to normal after each abnormal condition. Corrective action for said violation is to restore phone service to the fire alarm system, to restore communication to central monitor station, repair the smoke detector in the medical record room, restore a fire alarm system to normal status. The statutory requirements for notification of this hearing has been met by the notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed with the property appraiser record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. And I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On December 9th, 2024, I conducted a fire inspection at this address. I observed a fire alarm in a troubled state due to the phone line not operating. Subsequently, inspection conducted on January 16, 2025, found the fire alarm system still in trouble. In addition, I was provided with a fire alarm service report dated February 10, 2025, which states the fire alarm system dialer is not functioning and must be replaced, and that the central monitor station is not receiving signal. Additionally, the report stated a system smoke detector was also missing. Subsequent re-inspections on February 25, 2025, April 4th, 2025, and May 15, 2025, June 24, 2025, found the violation still outstanding and no reports have been received stating that the deficiency has been fixed. The city would like to request 30 days for the property to come into compliance with the remainder of the violations or a fine of $50 per day until such time that the property owner has notified the city of compliance.
Thank you. Okay, so can you, going to violation B, which is that the apparatus has to be reset essentially, right? To maintain normal, did you describe that? So what is the state of it currently?
The state of it currently is still in trouble. So even if you do reset it, the trouble is gonna come back because whatever is in trouble is not operating right now. It's the phone line, and the phone line is if there's an emergency and the alarm activates, is to notify the fire department. It's supposed to go to a central station, and then central station notifies dispatch and to send out a engine.
So then I'm not clear about violation B. Why are we finding why are you asking me to find a violation B if you're telling me that it won't even work to reset? Is that right?
Your Honor,
I'm confused.
if I could chime in, what
Yes.
Inspector Bailey is trying to say is essentially the fire alarm is stuck in a trouble condition. We can't reset it. No one can reset it because the phone line's broken.
Okay.
So that would be violation B, is the fact the fire alarm's stuck in a trouble state. And then violation A would actually be the fire alarm not communicating and the issue with the smoke detector.
Okay. So they're related, really?
Yeah.
Essentially one and the same.
Okay. All right, but so, and when you are requesting $50 a day, that would be imposed, it would only be $50, not $50 each,
Yeah.
correct?
Yes.
Yes, $50
$50 for both.
for both.
Yes.
No, let me be clear. Is it $50 for each violation that you're asking for?
Let me see what I. Yes. A fine of $50 per each violation. Yes.
Okay. But, all right, it's really for one condition though, right? I mean, again, it's all related, so.
Well, if they can fix the fine, and even though they fix the phone line, they still have the smoke detector that still also needs to be replaced.
All right, so there's both the smoke detector that's not functioning and the phone line's not communicating.
Yes, ma'am.
Okay. Thank you. Anything else before I make the ruling?
No, ma'am.
Thank you. I find respondent in this case in violation of the city code as charged, and that respondent correct the violations before 4:00 p.m. on July 25th, 2025, which is 30 days. In the event respondent does not comply by the state, a fine in the amount of $50 per day for each violation, or $100 total, will be imposed for each day the violation continues past the aforestated date. The respondent is further ordered to contact the code compliance inspector to verify compliance with this order. For purposes of for the hearing, when there isn't a functioning phone line like this, this is obviously a dangerous situation, correct?
So right now they're on fire watch.
They're on fire
which means
watch.
that, yeah. So every day someone has to walk the property every hour.
Okay.
That's going while they're still open. Someone has to walk and send that document to us directly, and they have been sending documents.
Okay, thank you. All right. Next case is Fire 19-2025, 1382 Howland Boulevard.
All right. For the record, my name is Jory Bailey. I am employed by the City of Deltona as the Fire Safety Inspector. This would be case number Fire-0019-2025, the City of Deltona versus EGE Holdings, LLC. The property address is 1382 Howland Boulevard, Deltona, Florida 32738. Parcel ID is 813038000080. This is a violation of City of Deltona Ordinance Chapter 42, Article 4, Fire Code Chapter 42, 186, which adopts the most recent edition of the Florida Fire Prevention Code, as adopted by the State Fire Marshal, which contains the Florida Pacific version of NFPA 1 Fire Code Section 13.1.9, which requires whenever impairments, critical deficiencies, or non-critical deficiencies are identified in a water-based fire protection system, maintained in accordance with NFPA 25, they shall be corrected in a time frame approved by the AHJ. Corrective action for said violation is to please contact your fire protection contractor immediately to have the repairs made based on the December 23, 2024 fire hydrant inspection report. Statutory requirements for notification of this hearing has been met by the notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed with the property appraiser record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, has been marked as exhibits and submitted to the special magistrate's clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On January 27th, 2025, I received a fire hydrant inspection report from North Florida Fire Protection for this location dated December 23, 2024, which stated a deficiency with the privately owned and maintained fire hydrant on the property. The report stated that the hydrant was unable to be flowed due to corrosion and moisture on the bonnet, and a rebuild and possibly replacement was recommended by the contractor. I generated a fire inspection report based on this report and sent it to the property owner on the same day. A reinspection report was sent out on March 10th, 2025. On April 7th, 2025, an email was received from the property owner inquiring which suite this was in regards to, in which we informed them it was for the property itself, pertaining to the fire hydrant. Subsequent reinspections reports were sent out on April 9th, 2025 and May 9th, 2025, with no further contact from the owner or reports received documenting that the fire hydrant has been repaired. The city would like to request 30 days for the property to come into compliance with the remainder of the violations, or a fine of $50 per day until such time that the property owner has notified the city of compliance.
Okay. And you said 30 days, correct?
Yes, ma'am.
I guess my only question is, do you believe 30 days will be sufficient to, you said that they would have to rebuild the fire hydrant, correct? Is that really a reasonable time to do that?
They have the option to rebuild it or replace it. And they, the fire hydrant providers should have parts on site to replace the bonnets.
Okay. So you leave 30 days to be a reasonable time to do that?
Yes, ma'am.
Okay. Thank you. All right. I'm going to find respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on July 25th, 2025, which is 30 days. In the event that respondent does not comply by the state, a fine in the amount of $50 per day will be imposed for each day the violation continues past the aforestated date. The respondent is further ordered to contact the code compliance inspector to verify compliance with this order. And I'm admitting the case file and PowerPoint as exhibits, and I find the notices properly given in this case. Thank you.
Thank you.
All right. I have a bundle here. This is, well, I'm not sure how to call this out. Yes. So it was a case for DEL 22-087, DEL 22-088, DEL 22-090, Massey, and DEL 14-178, repeat of 13-108, DEL 12-105, and repeat of DEL 11-021.
Yes.
Thank
Okay.
you.
My name is Todd Mead. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL 12-105, DEL 14-178, DEL 22-087, DEL 22-088, DEL 22-089, and DEL 22-090. The City of Deltona versus Carlos Antonio Enrique Montserrat and Lysandra Enriquez. The property address is 779 Tulip Street, Deltona, Florida 32725. The parcel ID number is 813-003-430-190. This property is brought before the Special Magistrate for a violation City of Deltona Ordinance Section 2-154, which states 90 days after the recording of a municipal lien, the city attorney shall be authorized to take legal action necessary to foreclose municipal liens on any real property. Corrective actions for this is to move forward with the foreclosure process.
Well, it's not a corrective action or a violation. You're just asking for
Correct, to go forward with it.
authority to move
Yes.
forward with the foreclosure.
Yes.
Is this a homestead property?
It is not homesteaded.
Okay. And then I think the ordinance says, is it 4 months or 3 months after?
The
That you just read, I apologize.
30 days after recording of a municipal lien,
Yes.
and then interest shall begin to accrue at 18% per annum for any unpaid portion thereof. Then it says the 90 days they can
Yes.
foreclose.
Yes. And has it been 90 days after the lien was filed?
Yes.
Okay. Are there liens for all of these case numbers that you read out?
Yes, if I can help with, this previously brought back as a reduction on the initial liens on the property of $125,000. The homeowner that bought Mr. Montserrat purchased the home. He did purchase the home and did receive proceeds to pay the liens to the city. He then petitioned to have the reduction. We had the hearing for the reduction. The city did come forth and offered a reduction of half. We decided the recommendation that was made to the city commission was for $10,000, the city's cost. That was presented to the commission. The commission did reject that offer and went back to have the current homeowner responsible for these liens, that he did receive the proceeds, and we were shared that information basically almost the day after we had that reduction hearing. The document that was the sales agent provided to the city showed that the homeowner received the proceeds of $125,000 to pay the liens or to basically try to seek a reduction with the city to get the liens paid off on that property. The property still had, the liens were also tied to a property, Eden, I'm trying to think of the address, 1447 Eden Drive, which was also the previous homeowner who sold the house to Mr. Montserrat. But Mr. Montserrat did know at the time he was receiving proceeds to seek out and returning the house, paying off the liens that were owed to the city.
Okay, so you're saying, so they, in the closing on the property, you're saying he did receive that amount to pay off the liens and
Yes.
and has not?
He knew the liens were there when he bought the property, because and then he consulted with the city, how do I either pay this lien and we directed him to you can come forth, special matter, and ask for reduction. We tried to work it out, or at least present him half. He proceeded, he didn't share that with us until, again, it was the sales agent on the property that shared it with the city.
That he had received the proceeds to pay the full amount of the lien.
Correct. And he
has not done so.
And then even after the commission meeting, I think he did speak with Mr. Rond about what else he could proceed, at least get the public records on the commission's rejection. I think there was in that.
But again, he did not pay off the liens at this point.
No.
That is correct.
Okay. All right. So I will issue an order authorizing the foreclosure to proceed, given that it is beyond the 90 days required.
Right.
Thank you.
All right?
Yes.
Thank you.
All right, thank you.
Is that it? All right. Anything else before we adjourn? No. All right, we are adjourned. Thank you. You need to make sure.